Hi, everyone. I'm Jay Lazega of Lazega Johanson. Welcome to our session on virtual annual meetings and ballot elections for boards of directors of community associations. Thanks for joining us. I'm with Jamie Lyons and Catherine Roberts today. Hello, Jamie and Catherine.
Hello.
Good to have you here. We're excited to do this program. For those of you who have been following our L&J morning break, Thursday morning, 15-minute morning breaks. This will be a little different, a little more in depth, a little more detailed, but this is the time of year where we are talking about director elections and annual meetings. So I want you to visit our website, ljlaw.com, under our resources section. We've got a ton of information, including those earlier morning break videos, sample meeting notices and forms, sample signs for amenities, signs for other areas of communities, releases or waivers for operating amenities, lots of good things, lots of good information. And this will be on our website shortly after we do it. So today we're going to talk about annual meetings. And this is a crazy time. We all know this. And during this time, certainly in this year, we believe that nobody should be doing a live in-person annual meeting or election. Cramming people into a room, our traditional method of gathering, just makes no sense today. Maybe we go back to it in the future, but we're going to talk about alternatives that make much more sense, certainly in this year, but are platforms that you can use in every year, and you'll find them to be much more efficient, much more effective. And we're going to talk about conducting annual meetings, and then we're going to talk about conducting elections. And we're going to talk about the elections operated completely separate from the annual meeting. And then we're going to talk a little bit about conducting the election still at the annual meeting, but we really recommend that you don't do that. You separate the two, you do them separately. And we'll talk about why. We'll talk about platforms to use to accomplish them, how you do it. Ultimately, we think the best approach is a method of elections where we are using either a written ballot, paper ballot we send, or some online voting tool for the election of directors, where everybody votes directly over a fair enough period of time to give everyone a chance to vote, and then an annual meeting afterwards that ideally is mostly information. And one of the values of this process with voting by this ballot method where everyone votes directly is we don't need or use proxies for that process. Everybody votes directly. It is the most democratic method to vote. It certainly enfranchises or includes people in the most in the process. It is what we think to be the most fair and reasonable process, and it results in the most participation for people. So we're going to talk about that. We are going to start with Jamie discussing general requirements for annual meetings. One point I want to make quickly. The fact that the pandemic is affecting all of our lives does not take away our legal obligation to have an annual meeting and a director election every single year. We don't get to decide this year, oh, we'll just skip it and come back to it next year. We still must do them. So these are methods to accomplish that so we can satisfy our legal duty. So those actions still are going to be similar to what we do with in-person meetings, in-person elections. So it's important to start with procedural requirements if we're holding annual meetings in person, if we're doing elections there at annual meetings, because those procedural requirements generally are still going to apply to this entire process, even though we will not all meet together live in the same room. Procedurally, those things still apply. So Jamie's going to start with that.
So a couple different things I want to share with you. And I'm going to start with some basic definitions just so that everyone's all sort of on the same page. So the first thing is, whenever you're going to have a meeting of your membership, you have to notify the owners that you're going to have a meeting. So there's a notice requirement, and we'll talk about what that requirement means and what information you have to include in the notice, and also how far in advance of the meeting you have to send your notice to your members. We're also going to talk about once you actually get together with everybody to have your meeting, whether it be in person or virtual, there is a threshold number of people who have to be present at the beginning of the meeting in order to be able to conduct business at your meeting. And that number is called the quorum. So we're going to have a little bit of a discussion about what is the quorum requirement, your threshold number of people present in order to conduct business. We're also going to talk briefly about the types of meetings you can have. And there are essentially three, and we'll discuss each one of them briefly when we get there in the material. So the first concept that I want to bring up is the notice requirement. And as Jay said, just because there's a pandemic does not mean we can just skip our annual meeting. We can't meet in person because it's too scary, and we don't want everyone together because of COVID, so we're not going to have a meeting at all. That is not a valid legal argument for any corporation. There are a number of different legal basis under which we can have virtual annual meetings. The Secretary of State has mentioned it, the governor has mentioned it, the Nonprofit Corporate Code gives us the power to do so, and a lot of your bylaws do as well. So it's not acceptable to say, well, we're just not going to meet this year. So we have to decide what type of meeting we're going to have. And you are required by law to have an annual meeting, which means one meeting for the year with your membership, just one annual meeting. And in order to have that meeting, you have to send notice. So a lot of your bylaws will identify the amount of time you have to give prior to a meeting. The Georgia law also identifies certain time restrictions. So I want to just address those three sections of Georgia law, and then always know that you must check with your bylaws. You've got to see what your bylaws say, because if your bylaws require that you give a little bit more notice than the law requires, you got to comply with your bylaws. So first things first, if you're a condominium, the Georgia Condominium Act identifies the amount of time that you have to give notice to an annual meeting. And if you're a property owner association, you also have a specific legal requirement under the Property Owners Association Act. So both of those two laws, the Condominium Act and the POA, both say that associations must give at least 21 days notice of your annual meeting to your membership. Your documents could give 30, could say 30, and that's fine if your documents give you more notice requirement, but not less. So 21 days is the minimum under the under the Condominium Act and the Property Owners Association. For homeowner associations, you are not subject to the Georgia Condo Act. You're not subject to the POA. You are still subject, though, to the Nonprofit Corporate Code. So for HOAs, the Nonprofit Corporate Code requires notice for annual meetings between 10 and 60 days before the annual meeting. That's your window. So you must give notice between 10 and 60 days prior to the meeting. Again, your documents could, as an HOA, your bylaws might say the association has to give 30 days notice. If your bylaws say 30, you can't give 10, you have to give 30. So just keep in mind, bylaws will be very relevant in this discussion, in this evaluation for you guys as board members and managers. But the law fills in the gaps if your bylaws are silent. So notice has to be sent in that amount of time, and then the notice has to include certain things. So for any regular meeting of your membership, for an annual meeting that is in person, regular sort of in-person meeting, traditionally, you would normally say the name of the corporation, you would identify the date of the meeting, the time of the meeting, and you would identify the location of the meeting. There are other things you probably traditionally put into your meeting notice, and that's fine. But by law, those three things are what's required: date, time, location. So the same is true for any type of meeting that you're going to do virtually. So if you're not going to be in person, which we strongly encourage you to not be in person, and you're going to do a virtual annual meeting, still date, time, and location. Date and time is easy. Location on your meeting notice for the virtual meeting should be the link or the website address for the meeting that you're going to host. So if it's a Zoom meeting, you give the link for the Zoom meeting with the Zoom ID. If it's a GoToMeeting, you do the same thing with the GoToMeeting ID. Whatever electronic platform you're using doesn't matter, but your location in your notice identifies that platform and the meeting ID number so that people can get online and come to the meeting at the right time. So that's going to be the same for any type of community. What you have to put into your annual meeting notice is identical as far as those three items, whether you're condo, POA, or HOA. So then the next part of the discussion is when we get to the meeting and we show up online and people are signing in and saying, hi, here I am. How many owners do you need to have a quorum? What is your minimum number, your threshold number in order to conduct business at a meeting? So if you're in person, it is the exact same thing, the same number if you're in person as if you are virtual. So again, I go back to my law. Always start with your bylaws, but I don't know what every one of your bylaws says. So you have to start with your bylaws and see if there is a quorum requirement for membership meetings. Whatever that says, we have to compare against the law, make sure we're not in violation. And as long as you're in compliance with the law, you comply with your bylaws. But some bylaws are silent. Some bylaws don't have a quorum requirement. Some bylaws say the quorum requirement for membership meetings is as described by law. So you have to know what the law says. So the Condominium Act and the Property Owner Association Act both say that quorum is more than 1/3 of the eligible members who are present at the meeting. So more than 1/3 eligible voting members and present at the meeting. So those three things are important in condos and POAs because that's what the law says. You have to have more than 1/3 of the eligible voters. So if you have 120 units in your condo and 30 people are delinquent and ineligible to vote, your quorum requirement is based on 90, not 120. And your quorum requirement is you divide by 3, essentially. You get 1/3 of 90 is 30, but the requirement is more than 1/3. So it's going to be 31 as your quorum requirement, just slightly above 1/3.
Jamie, it's worth mentioning here that like Jamie said, very important to read our documents, our bylaws, because we should not ever make assumptions about the authorities and procedures we have. And she mentioned eligibility and suspension, and I think most of us want to just assume delinquent owners lose their voting rights, or even in other contexts, we have finding power, so all we have to do is tell somebody, you're fined. But our bylaws or our covenants may have specific procedures to follow to implement those. And judges don't like close enough. You've got to strictly follow any procedures that our bylaws or covenants specify for all of those things, all enforcement actions, suspensions, fines, other things. And if you don't, then our action of suspending would be invalid. So right. while our bylaws may allow for suspension, we need to read them to see if we've got to take affirmative steps to actually accomplish that.
Right. So I was going to get into that next, which was the next piece of this is, that's okay. Thanks.
We made it 10 minutes without stepping on each other.
I explained that, it's more than 1/3 eligible votes in person, being present at the meeting in person, essentially, or virtually in person, for condos and POAs. And the concept of eligibility is also consistent in HOA situations. The Nonprofit Corporate Code says that your quorum can be 1/10, if not otherwise described in your bylaws, 1/10 of eligible voters represented at the meeting. So again, we've got a number, 1/10, we've got your eligibility requirement, and then we've also got the concept of represented at the meeting. The difference here is that under condos and POAs, the person has to be present to count towards the quorum. Under the Nonprofit Corporate Code for HOAs, the person has to be represented in order to count towards a quorum. There's a court case that has established that represented means if I can't be at the meeting myself and I give Catherine my proxy to show up as me, if I'm in an HOA, Catherine representing me counts towards a quorum. So I would count towards a quorum and she would count towards a quorum if both of us were owners. Under the Condo Act of the POA, it says that the person has to be present, which means I can only represent myself at the meeting. If I give Catherine a proxy to be me at the meeting, the proxy under a condo and POA does not count towards quorum. Catherine can vote on my behalf at the meeting, but I don't count towards a quorum if it's a condo or a POA unless our bylaws allow that. So keep in mind, most of your bylaws, and I go back again to the bylaws, most of your bylaws for condos and POAs are going to say that you have to be present in person or by proxy. So most of your bylaws will allow proxies for quorum requirements for all types of associations. But I just want to let you know that if you're a condo or a POA, you need to make sure your bylaws identify that, because otherwise proxies cannot be used to count towards quorum. Going back to Jay's comment about eligibility, I want to just be a little bit more clear. I want to give you a specific example. What we see in a lot of our documents, doesn't matter if it's condo, POA, or HOA, a lot of our documents say in them that in order to be ineligible to vote, the board may suspend the right if you are delinquent or in violation. If your documents say the board may suspend the right, and the board doesn't take any affirmative action to actually tell me I'm not allowed to vote, then my vote has not been suspended. So the board has to sometimes do something proactively to tell me my vote is suspended in order for that to be the case. Otherwise, I'm still eligible to vote. Some documents, on the other hand, say if you're delinquent or in violation, you automatically lose the right. You're automatically suspended from voting. If there's automatic suspension, there's a distinction there. You don't have to do anything special or proactive to remove my vote. I'm automatically suspended. So again, I go back to your documents, very specific per association. You need to know what your documents say about this.
Jamie, one tricky spot I just saw yesterday, again, very common, that lots of us have seen our finding provisions, and they usually say if you're going to find someone, you have to send them notice, offer them an opportunity for a hearing before the board. But a good number of community documents say that you have to do that hearing at notice, written notice, and state they have a right to request a hearing or finding or suspension of rights. So in some communities, you got to do that just to suspend voting rights. Going back to what Jamie said, very important that you read the covenants and bylaws and understand the procedures.
And specifically about this, I mean, keep in mind, unless you amend your bylaws at any given time, your bylaws are going to be the same for every meeting that you have. So if you read your bylaws and write this stuff down, like what are the requirements of our documents to do these things, it's going to be the same every time over and over again.
Yep. Don't
rethink the whole process every single time you have to have an annual meeting. Do it once up front, figure it all out, write it all down, keep notes of that so that next year, the next people will look at your notes and say, oh, we've already got this procedure settled. So it takes some time to flip through the documents and make sure you're not missing anything, but a legal opinion on this issue is huge because you can use it over and over again every single year. And then you're not rethinking the whole process. The next piece of what I wanted to talk about, and this is a really sort of brief discussion on proxies. I mentioned the term proxy when we were talking about quorum, and a proxy is a written document that essentially gives the owner in your community the right to convey their representation to someone else for a meeting. A proxy is only valid for an actual meeting. You don't use proxies for any other purpose other than I can't attend the meeting, so I'm going to give my proxy to Catherine. And Catherine then attends the meeting on my behalf. I'm not going to go into a lot of detail on proxies because for the most part, the discussion that we're having today is about virtual meetings and about elections by ballot outside of meetings. For those two things, virtual meetings and elections outside of a meeting, you don't need proxies at all. So I don't want to spend a whole lot of time talking about proxies, but I do want to sort of bring it up that at an in-person meeting, a proxy allows me not to show up and essentially Catherine to be my representative. And more about that later. You're welcome to email me afterwards or ask me questions about your particular documents related to proxies after you've had an opportunity to review the rest of this material that we talk about in our virtual class. So the last thing I really wanted to touch on is the concept of which type of meeting to have. And I've got, there are essentially 3, and I've got some associations doing all different kinds. We're talking today about annual meetings. And an annual meeting is the required meeting that is required by the Nonprofit Corporate Code of all corporations in Georgia, required to be once a year from the time that the corporation is established. So even when the developer is in control of the association and runs the board of directors, there still should be an annual meeting. I know there's not. I know they skip them. I know that they think, who's going to sue me? But legally speaking, they're required to have that annual meeting, even if it's developer controlled, as are you for all board controlled, owner elected board controlled communities as well. So annual meeting is one type. Anything that you need to accomplish by vote, if you're not doing it outside of a meeting, if you want to have a meeting about a particular vote and it's not the annual meeting, that meeting is called a special meeting. A special meeting is for any purpose where you want to take action other than at the annual meeting. So come up with something where we're having a special meeting for one of my clients because they're amending their bylaws. They don't have the ability to take action outside of a meeting, and they want to vote like we're going to suggest in the next couple minutes. They want to have their elections by ballot outside of a meeting this year. So we have to amend their bylaws to allow them to take action out of a meeting. So we're having a special meeting to vote on amending their bylaws to allow us to not have meetings anymore. So, and to do things outside. So that would be a special meeting called for a special purpose. Important thing that you need to know about that is for special meetings, the notice for the meeting has to identify what we're going to do. So at this special meeting where we are amending the bylaws, our notice is going to say, we're having a special meeting for the purposes of voting to amend the bylaws. You have to have the specific reason why you're meeting, and the verbs matter. We're not meeting to discuss voting on the bylaws. We're meeting to vote to amend the bylaws. So you want to be really careful with your special meeting notices about the actions you are describing. And then the last type of meeting is essentially like what I would call a town hall gathering, where you're not meeting for the purpose of taking action. You're not having an annual meeting. I've got an association that is amending their covenants, and they want to have a Q&A session with their owners. They want to have me on screen. Their owners come to the meeting and ask questions. We're not going to vote on anything. We're not doing anything. We're not conducting any business. We're just meeting to discuss stuff. So that's really a town hall where whoever shows up, shows up. I don't care if I have a quorum. I just show up to the meeting and ask my questions. I can leave whenever I want to. There's nothing actually happening from a business perspective, just some informational discussions. And that I would call a town hall. And that's pretty much what I wanted to cover. I wanted to cover notices, quorum, types of meetings. And I got a little proxy in there too. So great. I think next up is Catherine. Catherine is actually going to be talking about how to schedule and what to do to create this virtual annual meeting, and to also conduct these elections for your boards outside of that meeting, not during the virtual meeting. So Catherine, I'm going to turn it over to you.
Thanks, Jamie. Okay, yes. So I'm going to review with you guys just the process for conducting elections outside of a meeting. I'm going to go through the authority that you have to do so, the methods for conducting it, and go through some of the notices and the recommended steps that we advise when pursuing this process. So step one, you always want to check your bylaws, as Jamie was noting earlier, and Jay as well. It's very important to make sure that you have the authority to take action outside of a meeting. What you're typically looking for in your bylaws is a provision that says, it's a specific provision that says the board can take actions outside of a meeting. The association can do that for their meetings and whatnot. You will typically find if you have these provisions, you may have a ballot and a consent voting outside of a meeting provision. Sometimes you have bylaws that say nothing, they're silent, and in that case, you can default to the Nonprofit Corporation Code, which allows any corporation, an association, to take action outside of a meeting. Like Jamie noted earlier, you definitely want to check the bylaws because there could be the rare instance that you have a provision that is either it's very limiting, or it specifically says that you cannot take action outside of the meeting. In those cases, then, we certainly want to, you want to note that beforehand. And if you have to change it, like Jamie with her community, for example, they're going to have to change that for their meeting. But for the most part, most communities are going to have the authority. So after you look at your governing documents, determine authority, the next step is to determine what method you want to use to pursue the voting outside of a meeting, so for your election. So there are typically 3 separate methods. The first, of course, is using the mail-in ballot method. So you mail out the ballots or ballot voting forms to all of the members, and they fill it out and they return it to you by mail. Pretty straightforward and easy process. With ballots, and I think Jamie may have touched on this as well, but there are certain minimum legal requirements as to what the ballot has to include. And those are, the ballot has to include the proposed action. It has to specify the time by which the ballot has to be received by the association in order to be counted. And then it also has to indicate the number of responses needed to meet the quorum requirements. As to quorum, it's the same thing. We have to meet quorum if we are conducting our elections outside of a meeting, taking any action outside of a meeting. The way that it works is your quorum requirement, it's going to be satisfied if you receive the number of votes that equates to whatever your quorum requirement is. So for example, let's say that your requirement is 25% of the total eligible association vote. In order for the election to be valid, you must receive votes from at least 25% of the association members. So it's basically just making sure that the number of votes you receive is at least the quorum requirement that you have. So making sure that that the quorum is met and that your ballot is sufficient, that's always, it's a very critical part of this whole process, certainly something that your attorneys can help you with. And like Jamie said, on the front end, it's probably a good idea to get that help because, you can certainly reuse the knowledge that you have and the information that you get down the road. Okay, so the second method that a lot of communities are now pursuing is basically sending out the ballots electronically through email. Most communities are going to have the authority to communicate electronically unless they have some specific provision in their bylaws that says that they cannot. It's pretty rare, but again, certainly something worth checking off your list and making sure that you confirm that before pursuing this method. But assuming you do have that authority, email is great because, of course, it certainly cuts down on the mailing costs and the hassle of having to mail every single ballot to every single member. One of the important parts of electronic communications, of course, though, is you have to ensure that your owners have consented to communicate electronically. Most of the time, that's just by them giving you their email address. But if you do have some owners who have not consented to do that, then you will have to send those individuals a mail-in ballot. So you just want to make sure that you've covered that and that everyone does get notice, whether it's mail or email. But certainly with email, it can be quicker, and you can also use a PDF ballot, a fillable PDF version of the ballot. And that basically, it allows you to just send it over to the owner. The owner can fill it out on their computer without having to actually print it out, fill it out, and scan it back in and send it back. So it certainly makes the process much more efficient. So we have seen a lot of communities that are sending it out via email. And then, of course, the few that have to receive the ballots by mail, then that's certainly something that you can do. As a third method, there are the third-party voting websites. Some communities are starting to use these a lot more than they have in the past. They can be great. They can require a little bit of work on the front end because you have to get all the information, all of your voting information and all the information you would normally have on your printed ballot. You have to get that to the company, and they, of course, put all of the information into their system and they set it up for you. So they do, that using these third-party websites can be great because they can take on a lot of the work too, but it does require work on the part of the manager or board to get all the information together. And I think there can be costs as well to signing up to use these websites. But we have seen a lot of great results, and a lot of communities do enjoy using them once they get the hang of it. So that is certainly an option, but of course, again, with communicating electronically, we still have to keep in mind that those who have not consented to that will still be able to vote by ballot, which these days is going to be much less than it has been in the past. So those are the three methods: mail, email, communications, third-party websites. One thing to keep in mind with this process, regardless of what method you choose, is that it's going to take a little bit longer to conduct than just your standard annual meeting where you have people come in and vote for the election, because we've got these separate processes to cover. Nomination and voting process, which usually would be covered at the annual meeting, but you've got to account for those when you are pursuing this outside of a meeting. So many bylaws will provide for a nomination process from the floor of an annual meeting. And so one thing that we suggest, and I think our position on this as a firm has been, if we take these steps in terms of sending out, allowing for nominations to be made by sending out notices to the owners and allowing for the ballots, of course, all ballots are going to include a spot to write in your candidate's information. But at the end of the day, I think we agree that any provision in your bylaws that says that you are allowed to have nominations from the floor at a meeting, if we're not holding an actual meeting, then that's not a relevant requirement. But regardless, if we're still taking these additional steps, then we are certainly covered. So typically, as far as the timeline for this process is concerned, and the notice requirements, there's really only one time limitation that you're going to find in your bylaws, absent some wonky provision, that you're going to have to abide by in terms of sending out all of your notices and allowing for time periods for voting. And that is, we have to allow the owners a certain number of days to cast their vote. And that has to coincide with the required notice for annual meetings. So for instance, with POAs and condos, it's typically 21 days is the minimum requirement for notice for the annual meetings. And that means that in that case, you have to at least give your owners 21 days to cast their vote, to return their ballots to you for the election. So I think you'll see that we provided you guys a sample timeline, and I'm going to go through that quickly, but one of the things to note is that this really is a sample, and the way that we've drafted it, we've certainly drafted in a broad way, but also giving you plenty of time. It gives you probably more time than you may need, but certainly if you are pursuing this process for the first time, you might find that it's good to give yourself a little more time than you think you might need at the end of the day. So just keep that in mind, that you can certainly tailor this. Really the only requirement, like I said, is that we ensure that the owners get the required amount of time pursuant to the annual meeting notice requirement to cast their vote. So if you'll refer to the timeline, which we have posted, I think, the first step is it's basically the planning process. The board needs to start thinking and planning and preparing the voting forms, or secure the voting website, reach out to the voting website and that company if you're going to pursue that method, and also draft your first initial notice letter to the community. So you're going to start, and that notice letter is basically going to tell all the members, hey, look, we're going to pursue elections outside of a meeting this year. This is how it's going to work. We're going to send out the ballots. And describe the methods that we intend to use. So basically, it's just an overview and summary of the process, so the owners are aware of what's coming. Typically, on the front end, we say, allow yourself 3 to 4 weeks really to get all this information together and to plan. But it's discretionary. But I think certainly if you're going to have your attorney assist you or your manager, they need a little bit of time, of course, to get things together. So I think that's a pretty, that 3 to 4 week time frame for us, regardless, is probably right on the mark. So the next step is you're going to mail or email your notice of the process to the members. So you're going to send out that first notice. And then you're also, in that notice, you're going to include a request for nominations. So you're going to ask people to submit their request to be considered as a candidate to be nominated to the board. And, I think one thing that we have found that's pretty helpful and that many communities are taking advantage of is to send out a separate form with that letter. It's what we refer to as a candidate nomination form. And it just allows for owners to just fill out, you require certain information, the owner's name, address, and allows them to also put some biographical information in the form so that you have this, one concise method to keep all this information, and it's uniform, so everybody's going to be submitting the same information. So it makes it a little easier to organize. So when you do eventually send out this information on the candidates to the members, it's just a little bit easier to summarize. Of course, with these candidate application forms, we always, and for our forms specifically, but certainly if you decide to do it yourself, you want to make sure that in the form you reserve the right to revise or remove some information that, in the board's discretion, we just determine it's either unsavory or it's information that we just do not believe is relevant or needs to be put out to the community. So you're basically just reserving that right because, there could be some crazy things that are included in some of these forms that we may not want to put out to the community or just not relevant. So just make sure that you have that covered. So in that letter, you're going to include the deadline to submit nominations. And then once you get all that, if you send out the candidate application forms, once you get all that information back, you're going to want to give yourself just a little bit of time to compile all the information. And that's when you are going to draft your second letter to the community members. And that letter is going to include, the biographical information if you have that, the candidates, and then you're also going to provide notice of your annual meeting. And then the instructions, if you do decide to pursue a third-party website, instructions for registration on the website. And you're going to get, if you're not doing a third-party website, you'll of course include your voting form as well. So that's the time when you're just, in that letter, you're going to establish your, like I mentioned earlier, your time frame for returning the ballots. And of course, like I said, that's going to be whatever time frame it is that is required for notice of the annual meetings. So you've got that covered. You've got your second notice out, and then once the deadline hits for people to return their voting forms, you'll also want to give yourself just a little bit of time to count all the votes, to get everything ready. And really at that point, a lot of communities, and like we have included on this timeline, but we basically, a lot of communities like to announce the election results at the annual meeting. You certainly don't have to do that. I'll touch on that in just a minute, but it's certainly easier. That's the way this timeline is set up. But I just want to mention that because it's possible to do it different ways. So there's a lot of flexibility there. So so basically, to summarize, you're generally going to put together several documents through this process. There's going to be the initial notice letter to the community and the request for nominations. You're going to have your candidate application form if you decide to do that, which we do strongly suggest. And then you're going to have your second notice of the annual meeting, and then you're going to have your voting form. So those are just the general documents. You may decide that you want to include some additional items, but those, generally speaking, that's what we see communities wanting, what we prepare for our clients. So, and then, like I said, in terms of announcing the results and when you conduct your elections, most do it so that it's easier, where they can just announce the results at the annual meeting. But if you decide that, you, for whatever reason, you would prefer to conduct the elections after the annual meeting for whatever reason, you can do that. Or, at the end of the day, you could just mail out, even if you do conduct your elections before the annual meeting, you can mail out notice of the results too before the meeting. But if you are going to announce your results at the annual meeting, we're just going to want to make sure that anyone who wasn't there or wasn't present at the annual meeting gets notice of the election results. So yeah, I think that pretty much covers the election process.
Great. Important to remind everybody that this idea is that the election of directors, and we'll talk about it for other items too, this Catherine method is to do that entire thing separate from your annual meeting. Whether you do it before or after, or even at the same time, going on at the same time. This is an action you're doing separate. Now, some may ask, well, this doesn't even apply to us because our bylaws say you will elect directors at the annual meeting. And Catherine made the point that for most communities, unless your bylaws have something very unique and specific, you'll be able to use what the corporate code allows. The nonprofit corporation code says that for most things that you can do at a meeting, vote on at a meeting, you can automatically do by this method outside of a meeting. So most communities are going to be able to use this and do this, even if your bylaws say at the annual meeting, you will elect directors. And that's because the corporate code really says that there's only one specific required function or purpose for your annual meeting, not elections, not many of the other things we do, not our budget approval or budget presentation. It is the presentation of financial reports about the financial position of our community. It's the only thing the code requires to be done at the annual meeting. All these other things can be done separately. So Catherine's process is to conduct voting for the election of directors by this ballot method where everybody votes for themselves over this period of time. Now, with this program, we've got the timeline, Catherine's timeline for this. And if you look at that, it calls for, if you've got a mid-December annual meeting, starting that process about now. And there's some extra time built in that. But listening to what Catherine explained, it's pretty clear we have to do a lot more in this process than just send a notice for an annual meeting and show up at the annual meeting. So we certainly need to get started relatively soon, August, September, October, for December, January annual meetings, if we want to use the annual meeting to announce the results of the election. Otherwise, we do this whenever we want for the election of directors. But if you're going to make the process, and Catherine explained this, the best method is to backdate, create an internal calendar, backdating from when we want it to end, to leave enough time to satisfy all the notice requirements, but also leave enough time for all of us to actually do the pieces of work in it. So if your managing agent is collecting the nominations and gathering those, for example, and then putting it into a document, don't leave yourself only one day to accomplish all of that. This allows us to have time to actually do the work to make all this happen. So while there's extra time in there, this process takes time, and it's time to get moving, to start thinking about it. Now, we definitely think it makes more sense, particularly in this year, but once you do it, you'll see for future years too, to do your election separate from the annual meeting. And also do any voting that we have to do separate from the annual meeting, so that the annual meeting is mostly informational. Now, there are things members can do at an annual meeting, raise motions and votes that we have to be prepared for. We'll talk about that a little. But if we can accomplish what we need to get voted on in this method, and then have mainly an informational annual meeting, life is much easier. We absolutely can, and the three of us have done many virtual annual meetings where we have physically done the election of directors at that meeting as well. And it can be done, absolutely. And most of the video platforms, whether it's GoToMeeting, Webinar, Zoom, any of the others, most will allow us to do that. But it is so much more complicated that we don't think it's the way to go. And we're not going to talk a whole lot about how to do that. If you want to know, reach out to us, let us know, and we'll work through the process of virtual annual meeting with an election added.
Right.
But I'm going to talk mostly now about a virtual annual meeting with us completing the Catherine election by ballot method separately. So I mentioned that this should be everything that we need to accomplish that requires a homeowner vote. We may be proposing a special assessment that requires a homeowner vote. We may be proposing approval for a loan, us borrowing money, amendments. If we need affirmatively to have the owners vote to approve something, we could and should package that with our election, or a whole separate ballot in lieu of our meeting, our annual meeting. Accomplish the vote that way, and we still have to satisfy the quorum requirements, any specific thresholds in our documents for an action. We all know amendments, for example, special assessments may require higher approval than just a quorum approval. We have to satisfy those, but anything that we need a vote for, take out of the virtual annual meeting and put into this ballot method. We then go into the annual meeting, and we have to do the financial presentation. We talked about that. That's the one actual only requirement for the annual meeting. And obviously financials, we do this all the time. We send them out in our notice packages with meetings. We print most of it, and then maybe we do summaries of the financials at the presentation at the annual meeting. We'd essentially do the same thing. We'd send them out still with our package. We can post documents to almost any virtual meeting platform, so they have it there as well and they can look at it. And we can give high-level summary reviews, and we can answer questions about it. But what we do with this annual meeting then is essentially taking out the election piece, the same as what we would do at a live in-person meeting, or just at a live virtual meeting. So it means that if there is business to conduct, we still have to satisfy the quorum. To be able to do any of that, we have to check people in and validate votes. We may have members bring proxies, and we have to check those in. If we're not trying to accomplish votes at the annual meeting, and our bylaws don't require us to provide proxies, like most do not, the law does not require us, and we don't even need to provide that before the meeting. Provide an agenda and information about what we're gonna do at the annual meeting, and then what we're not. The election. You members know we've conducted the election separately. We're gonna present reports at the annual meeting. We're gonna provide a forum for new business and question and answer, and that's it. We then go through our financial, so we check people in. It will take some time. If we're using a registration system with these online platforms, we require people to register with their name, email address, and property address, and the email address that they will use to log in. Most of these platforms allow you sending unique invitations. Somebody in our leadership group manages, whether it's a managing agent or others, manages those that register and those that come in. We may have multiple people from a home. My wife Susie and I may both want to come on separate devices. I may be stuck at work and she may be home. And it may be okay for us as a community to allow that. We may say as a board, that's fine. But for the purposes of quorum and voting, if it comes up, we've got to make sure that we're treating us as a single home. So somebody's got to manage the check-in like we normally do. And if somebody brings proxies, we have to manage that. Once we get through the check-in process, and I believe Jamie talked about this, we're required to have an annual meeting in every year. And we have that meeting when we issue a notice, call a meeting, and open that meeting. First item of business at a meeting is, obviously welcome people, but then confirm whether or not we have a quorum. If we don't have a quorum, we can't transact business at that meeting, but we technically still have a meeting. And it becomes what Jamie talked about is the town hall type, where it's primarily informational. We can't vote on anything, but we do have a meeting. And the reason that's important is our obligation under the code is to have a meeting every year. If we just say we have a quorum, we don't have a quorum, so we don't have a meeting, see you later, we might breach our duty under the code. by this constituting a meeting, it satisfies our legal duty. So if we don't have a quorum, our process is check in, open the meeting, welcome, announce. We do not have a quorum, so we cannot conduct voting business. But we're going to provide information. We may even do Q&A. We then have, because we have a meeting, we take minutes of that meeting to record that we called the meeting, that we didn't get a quorum, and that we provided reports. We now have documentation to demonstrate that we satisfied our duty to hold an annual meeting. So now let's assume that we do have a quorum at the meeting. If we don't have a quorum, no voting can happen, and all we do is go through our reports, and we may want to allow Q&A. Almost every platform we're going to use for the online meeting platform will allow us to have questions or chat come in from people. There are different ways in all the platforms to conduct these meetings. Many of them will allow the typical Zoom experience that we all have with our friends, where 10 of us are all on video, all talking at the same time. That's frankly not what any of the three of us think you should use, that type of platform, not necessarily Zoom, for the meeting. Zoom at a higher paid level and some of the other applications will allow more of a classroom type forum where the leadership group, the three of us, Catherine, Jamie, and I, can present. We're live, we have video, we have audio. You, the audience, don't have video, don't have audio, you're muted. You have the ability to, depending on the platform, chat or ask a question, raise a hand, some have the hand raise, and we have the ability to recognize you, give you a mic, give you a video if we want, or just have somebody in our group assign the task of monitoring the questions and present it to our group if we think it's a valid question, a reasonable question at the time. So we think the better platform is one where you manage it like a seminar like this. We then do our presentations and we allow people to ask questions. Questions almost always will come in throughout the whole thing anyway, and we can choose what questions to answer. If, like all of our meetings, we've recommended this for decades, you should have timed agendas for your meetings, and we should give those to owners so we can put closing times on the different pieces of business or things we're doing. Get through what we can in that time. Thank people, tell them that we are happy to continue to take their questions after. They can reach out to us or we can reach out to them. But we move through our agenda. If there's no quorum, no voting. If there is a quorum, first thing we're going to do in actual business type work, usually, is present our financials, present our balance sheet, P&L, comparison year to date. We may present and go over our budget. We may take questions. One of the things that is very commonly misunderstood certainly in our Georgia communities, but I think also around the country, is the procedure for adopting budgets. Most of our community legal documents have a provision that, say, the board of directors adopts the budget, and then often it'll say the board's got to send that budget out to the membership some amount of time before the annual meeting, or maybe before the first installment date for dues for the next year. And then the budget goes into effect unless the members veto the budget at the annual meeting. Well, we're holding an annual meeting. And if we have one of those provisions, which is most of our communities, we've now just presented our financials, presented our budget. We may have taken questions. A lot of communities do this wrong, and they'll then stop their meeting and they'll say, okay, now let's vote to approve our budget. And Jamie's nodding her head. Never do that. If it is not a requirement in our documents to ask the members to approve the budget, we do not do that. They have a right to make a motion to do that. We do not have to make that motion for them or accommodate their vote to do that. So we often get asked questions. Well, if we're going to do this Catherine voting method to elect our directors, but we know the members have a right to veto the budget, should we put that on our ballot so they can veto our budget? And we always say, look, you've now spent months putting together, analyzing, putting together your budget, because your legal duty is to run this business and make the financial decisions about what it takes to do that. And because we are the ones who get sued if it doesn't go right. After that, why would we enable and make it easy for the homeowners to accomplish that undermining of our efforts? Yes, they have the legal right to motion.
I want to also mention we're still having an annual meeting. So if the owners wants to vote down the budget, you know, if Jay's the president and I'm a member of the association at the annual meeting, I can make a motion still, because we're going to still have an annual meeting. It'll be virtual. But as long as there's a quorum, I can still make a motion to vote the budget down. The board doesn't have to proactively bring it up and say, hey, anybody want to vote the budget down in their ballot with their election?
What we do, yeah, exactly. So in these platforms, let's say we're using hand raise. In the beginning of the meeting, we explain to people how to use the platform, how to ask questions, whatever it may be. And people may use the hand raise for making motions, or we say use the chat to make a motion. We get through the presentation, we ask and answer questions about the budget, and then somebody could use that and say, I make a motion to do this. They have a legal right to do that. And if that motion is made and seconded, although a lot of us think seconds are kind of extraneous, someone's going to second almost everything. If there's a valid motion at a meeting on something that people have a right to vote on, we have to accommodate that vote. We can't say no, but we don't have to ask them, hey, does anybody now want to make a motion to undermine the budget we just spent 3 months putting together? So,
and Jay, if there's no quorum at the meeting and I make a motion to vote the budget down, what do you do?
If there's no motion, if there's no quorum, we can't even have a motion for a voting action, right? So the motion is out of order. So we've answered questions. Some boards will now be at an annual meeting. They'll say, let's take a vote. Is there any motion on the budget? No. What we do is we intentionally pause for 15 to 30 seconds to see if anybody figures out that they could make a motion. And if not, we say, okay, we're now moving on to the next item of business, which is whatever, ACC report, or we're going to report on the accomplishments over the last year in the community, whatever it may be, or new business, question and answer. And so we go past that if we don't get the motion. We don't wait around to let them make that motion. Now, that's not the only motion members can make at annual meetings. They can make lots of motions. I move to adjourn, close this meeting. I move to replace the presiding officer. I move to do other things. If there are valid motions and we have a quorum, we've got to accommodate that vote. And I'll talk about how we're going to do that, but I want to put it in the context of the budget disapproval first, because we were just on that. So most of these provisions that call for members to be able to disapprove or veto or vote down the budget require a pretty high threshold to accomplish that. In most cases, it's at least a majority of the whole community. Our quorum might only be 25% of the community, but this may be a higher threshold. If we have that kind of situation, we then could have a circumstance where we have a quorum. We have enough to hold a meeting, but not enough for people to vote to veto the budget. We may have 25%, but not 50%. In that case, if someone makes a motion, it technically still then is out of order because the vote cannot be accomplished. not enough people to do it. Now, just politically, sometimes we go through the vote anyway, knowing it fails. But we also could say, we're sorry, but the vote requires this number. We don't have this many participating, so we can't conduct a vote. Move on to the next item of business.
I want to make a point here, though, that guys, what I told you about before, when you were thinking about your reading through your bylaws and figuring out your notice and your quorum requirements, you know the option exists here to potentially vote the budget down. Before the meeting, you should already figure out, if we get to the quorum requirement, how many people have to vote the budget down. So you know what that number is before the meeting starts. So you know if you're going to be able to get to that number as you get people signing in for the meeting. Know these numbers in advance of your meeting. Don't just try and figure it out in the middle of the meeting. Think about this, evaluate it, put it on paper, know it for now, know it for later. It'll be the same number next year. So just kind of keep that in mind. Figure it out.
Now, let's assume they actually have enough people to accomplish any vote for a motion they make. We got to conduct a vote. Most votes we conduct are essentially yes or no votes. One choice vote, pick one or the other. Election of director is very different. We know how that works. We may have 3 open positions, 5 candidates. Much harder to accomplish election of directors with this method I'm going to talk about for the yes or no vote. But we now have to hold the vote. Someone made a motion to veto the budget. Okay, we've got to vote it. And there are enough people. So there are different methods to accomplish this. And I'll talk through those. We will accomplish the vote at this meeting right now. But if we have to physically then accomplish the vote counting right now, while we're doing our meeting, we, in many of these voting situations, are going to have so much disruption that we're going to make our meeting ineffective. And it essentially, if there's a closed vote and we have to go back and live right now, figure out the people who are here, who may have voted, who has a proxy, who's husband and wife, how are we going to manage the vote while everybody's waiting on the video? We've essentially made this an ineffective meeting. But nothing in the law requires us for most of these votes to announce that result right now at the meeting. So if someone makes a motion and we've got to vote on the budget, I'll come back to how we do the vote. But we got to vote. We have to give them the vote. We conduct the vote. We have all kinds of votes, and we now have to go out, do our due diligence of scrubbing it, figuring out what the actual result is. The best method to do this is for us to say, look, we're going to conduct the vote. We're going to record all the votes. Most of these platforms will do it, whether it's in reports or whether we screenshot it. And then we're going to, after this meeting, count the voting and announce the results tomorrow or the next day. And we may, let's say it's on something that is maybe kind of, potentially controversial, like the budget vote, or maybe it's the election of directors. We may, in this counting, bring on some non-board member assistants to independents to help us vote. But we're going to announce the results later, and then we're going to move on with the meeting. So we're going to do the vote, and then we're going to go to the next thing of business. And that gives us time to get things together, to not rush, not make mistakes. And thinking about the budget, if we don't know the results of this vote until tomorrow on a budget that's not going into effect for 30 days anyway, the world does not end. Everything is fine. But if we stop the meeting to try to manage this, possibly making mistakes because we're rushing, lots of bad things can happen. So now we've got to take a vote. We're not going to give them results in most of these. Now there's some things where maybe we give the results because it's very obvious, but I'll talk about that in the method. One of the easiest ways to do this vote is we're going to vote yes or no on disapproving, vetoing our budget. You're going to either vote yes, I want to veto this proposed budget, and we're going to go back to last year's, in which case you vote yes, or you're going to go vote no. I am okay with this new proposed vote budget, so I vote no to the veto. We are going to vote. Now we can use on different platforms, use the question, use the chat, send your yes or no. I like on those yes or no's, use the hand raise in the platforms that have it. So everybody who votes right now to veto the budget, voting yes to veto, raise your hand on the menu bar of the application. And we're going to wait, and we're going to wait for everybody to do it. We're then going to, most of the platforms may save that, but we're also going to screenshot and save it as our record of the vote, just as if we passed out ballots at the meeting. Next, everyone who votes no, take all your hands down. Everyone who votes no, raise your hands. Again, we count. Now, if every hand other than 3, if 100 went up yes and 3 went up no, we don't need a whole lot of offline counting. We know the result of that election, and we may be able to just say, okay, it failed. But if we have to do any counting, real counting, take it offline and we do the voting after. Now, it is possible to do this with the election of directors. And it's possible to do that by saying, okay, here are our 5 candidates or 8 candidates. Either send us in the question or chat up to 3 names, and then we'll go back and count them after. Or we can literally hand raise for everyone. Everyone who votes for Jamie, raise your hand using the hand raise function.
Catherine?
And Catherine, raise your hand. But that is so burdensome. Don't do it. Do the Catherine method. Now, if we do this, Catherine method, and then we do this annual meeting virtually, it is very possible. And I've done dozens, maybe 100 of these now virtually as annual meetings. And if we follow the trend, lots of meetings, most of these meetings are going to make it through informationally without any motion or voting at all, which is okay because anything that we needed to vote for, we already did through Catherine's method. So that if a motion came up, it's only something we hope would not happen anyway. We may get through meetings easily, 1 hour, informational, allowing a fair amount of time for owners to have Q&A, give them some opportunity for new business, motions, things like that, and then get out and be done. We just have to accommodate that if someone does make a valid motion, we have to be able to vote on that in this platform. Easiest way to do that, go into it in the front end, pick what tool we're going to use for the vote, and let everyone know the vote will happen, the results will come later, just like every other election we participate in. Okay, and then we close the meeting. Once we've created these platforms, the documents that Catherine talked about for electing the board of directors, or special assessments, or anything else we may vote on. Once we've created those documents and the method and our kind of schedule and assigning who will have to do what, and once we've created the platform for this virtual annual meeting, you don't have to recreate it again in future years, which means it becomes so easy in future years. I guarantee when you do this once, you're going to start using this as your normal model for the future.
I want to say a couple things, just 2 things, Jay. First off, when we're doing the Catherine method of voting on something outside of a meeting, and we're taking a ballot vote outside of the meeting, I mentioned earlier that proxies really aren't relevant because I can vote on my own ballot. Catherine can vote on her own ballot. I'm voting, not going to a meeting to vote. So if I can't make it to the meeting, who cares? I still got to vote. So in my opinion,
we have a long period of time to do it.
Right, and on whatever time frame, whatever ballot deadline I have, I can vote at 2 o'clock in the morning and send it in if I feel like it. So it gives me a lot more flexibility individually to vote when I want to and not have to be tied to only voting at a meeting. And to me, that's sort of the most prime, that's like the easiest form of voting, and it allows me to always cast my own vote. It allows me to not have to use Catherine to cast my vote for me if I can't make it to the meeting. So I think it's sort of the purest form of voting. It's the most representative because each person gets to vote their own ballot. And so I really, really like that concept. And you don't get that option if you're voting at a meeting, whether it's in person or virtual, because some people can't be there at that meeting time. So the two pieces there are that proxies really aren't necessary, and it's really the truest form of voting because everyone gets to represent themselves with their own vote. And I really, really like that.
I agree, totally agree. And whether we use the online voting platform, and there are a number of out there, you don't have to use that. And some, maybe our kids are smart enough to create their own. I'm not, but they're great. You pay for it. You pay to use those services. You could also do it by ballot. We've talked about mail-in ballot, but some of us want to reduce our mail costs or want to do other things to promote the environment and not print 400 of each of the documents in this process. To the extent that we have email addresses, in most communities, you could use that for delivery. And as you implement this process, you will gather more. This helps you build your email database for your community. And you can push, for instance, the ballot, fairly easy to make a paper ballot in a format. There are many others, but in a DocuSign format or in a fillable PDF, where literally on my phone, I can receive the ballot, type in my answer, email it back, and we haven't had to touch paper. Cost savings for communities are significant. Now, that works for everybody else. For me, I may need somebody to give me paper in very large fonts so I can read it, and then explain it to me 3 times, and physically be available when I have to walk it back to someone to hand it in. We still have to accommodate those people who refuse to use the technology, but more and more, we're not seeing a lot of that. People are
I'm seeing also not even so much DocuSign and fillable PDF, but I'm seeing the information being emailed out to the owners, and then the owner like either printing the document, the one ballot, filling it out and signing it, and then either taking a picture of it or just scanning it and emailing it back. And that's perfectly fine too. The picture and the scan and the email back is just a form of delivery. They're still filling out their own ballot, and that's perfectly acceptable.
Yeah, all that's fantastic. It lets people vote, and if they voted, is good enough, however they send it back.
Agreed.
Now, one final point I want to make on all of this is there are, in steps as Catherine talks about this, and Jamie talks about this, there are some very specific legal parts to this that you've got to do. You've got to involve your lawyers in this process.
Yeah.
They don't even necessarily have to be at the annual meeting, but they should help you set up your ballots and your elections. I think it's useful to have your lawyers help with the annual meeting, but maybe if we miss the procedural requirements on some of this, the whole thing is invalid potentially. So you got to do that. But it's relatively easy, and the value add, the cost savings on this kind of platform over a traditional is huge, especially long term.
Jay, one of the things there's one more thing I want to share that people ask all the time. They get really nervous because they never get a quorum. Year after year after year at these in-person meetings, they can't get a quorum. And the important thing to note here is that in almost all circumstances, when we're doing action outside of the meeting, the Catherine method of election, essentially, we're doing the elections outside of the meeting where people can, as I said before, send back their ballot whenever it's acceptable to them. You have to still have a quorum of ballots being sent back for the vote to count. But in almost all circumstances, you will get a quorum when you're dealing with a ballot method of election because people don't have to show up to something. Where you don't have a quorum often when people have to be there in person or show up on a virtual platform, if the vote is taken on their own time, almost everybody will respond. There'll be some apathetic people who don't reply at all, but you will undoubtedly get closer to or actually at a quorum, even if you never have before, if you do this from an action outside of the meeting perspective. I guarantee it, you're gonna have a much better turn.
I've seen and heard higher participation from the owners in every single one I've been involved in except one. And that
Same
was
here.
a higher
Same.
participation.
Yeah.
All right,
That's all I
so a lot of information. There's more on our website at ljlaw.com, the resources section. Feel free to use that. We hope this has been helpful. We hope
And
you
our
enjoyed
YouTube page, Jay, our YouTube page. We have more
Our
videos on our YouTube
our YouTube channel,
channel.
our
Sorry.
Facebook page. Visit all of those. We have great videos on those, so feel free to use them. Share them with your board members and others. We love to hear from you. If you've got questions on things, let us know. You can reach all of us at our first name and then first letter of this last name, Jayl, J Lazega, at ljlaw.com, Jamie L, Jamie Lyons, Catherine R, Catherine Roberts. And we love to talk to you. We love to help you. If we love to work with your communities. If we're not yet, certainly feel free to reach out to us. And we hope that you are safe and well and join us again. Visit us Thursday mornings for our morning break sessions. More info on that on our website.
At 11
Thank you
a.m.
very much, everybody. Take care.